This is an updated video on the Corporate Transparency Act, which was passed on January 1st, 2021. It says that every corporation and LLC in the U.S., even exempt companies, must file a report with the Financial Crimes Enforcement Network, or FinCEN for short. Now, this act was hidden inside of the National Defense Authorization Act. In fact, I've read every word, studied it with a fine-tooth comb, and studied what the authors say about it. So my goal here is to give you everything you need to know about it. Now, this act, which is under Title 31 of U.S. Code Section 5333, requires one to file a report about the beneficial owners of every company in the United States to FinCEN, a bureau of the U.S. Treasury. Now, first of all, this is a big deal because every owner of a U.S. company needs to do it, as you'll see. Everyone who sets up a U.S. company on behalf of others, including attorneys, need to do it. And because the penalty is up to 3 years in prison and a $10,000 fine for not doing it, plus under Title 18, $250,000 to $500,000 for providing false information about it. So the purpose as you watch this whole thing is to be the most complete video on the internet on the subject, telling you exactly what you need to do. So I highly recommend that you watch this short video to the end. And what really surprised me in the very end, I'm going to tell you what I uncovered. The most shocking thing about this brand new law and how it actually massively increases the privacy of ownership for corporations and LLCs for law-abiding citizens. Hi, I'm the business guy. And today we're going to talk about the Corporate Transparency Act. And if you could do me a favor, and please click the like button below. It will help me a lot for the YouTube algorithm, and I sure appreciate it. And in the comments, tell me what you think. And you can also click the subscribe button so that when more videos come out like this, you'll get notified. Now, I've been the CEO of a legal document firm for 30 years, and this is my perspective and that of our on-staff attorneys. But don't take this video as legal advice. You can call our office and speak with one of our attorneys. We've filed literally millions of pages of documents, most of which are corporations and LLCs, both in the U.S. and internationally. So some would say that would qualify me to talk about the subject. Now, first of all, my opinion. Now, there are incredible tax and lawsuit benefits for operating your business in corporations and LLCs. So in spite of this law, operating without a company really is not a good option. And frankly, as the CEO of a company formation firm, I'm not happy about this law. I think it's well-meaning, but it places an unnecessary additional ongoing layer of paperwork on the owners of every company in America. So let's say you have 2 million companies a year and 2,000 of them are bad guys. So 99.9% of the good guys have this extra burden for the 0.1% of the bad guys. Now, do bad guys lie? Of course they do. And reading through this law, the bad guys simply have to lie about who owns the company and have little side contracts about who receives the benefits, which they are supposed to report to, according to this law, but they won't because they're lying bad guys. Plus, when filing taxes, the tax filings already report the ownership of the company anyway. So there's no need for an additional reporting requirement simply because of government database inefficiencies. Moreover, there are easy and obvious ways around it. First of all, this applies to U.S. companies only, not offshore ones. So one can simply operate using an offshore company. Plus, there are certain kinds of trusts and companies that are on-staff attorneys set up to own real estate and other assets that a corporation or LLC can own, where one can maintain privacy of ownership. So if you're a good, honest business person who simply wants extra privacy, give us a call for more information and we can help you do it legally. And be that as it may, it is the law and we are all subject to it. And we have no legal choice but to comply. I don't like going through security at the airport either. I'm a good guy. I'm not going to hijack any airplanes. But I can lay on the ground and kick and scream and cry, or I can lay my bags on the conveyor belt and walk through the body scanner. Only one way is going to get me on the plane so I can see my family on the other side of the country. Now for a little background. The justification for Democrat Congresswoman Carolyn B. Maloney's sponsorship of this bill is that she says nearly 2 million corporations and LLCs are formed in the U.S. every year. Very few states require information about who owns them. And I admit, I must agree, we are the largest offshore formation firm in the nation, see offshorecompany.com, and in order to set them up, we need a reference letter from the person's banker, a reference letter from a CPA or attorney, the company purpose, the source of funds, a notarized copy of a utility bill or other residential address verification, and a notarized copy of a passport, so about 6 things. To set up a U.S. company, we just needed the name of the first director, and for an LLC, that can be another company as its manager. And that's it, no proof of anything. So they say that criminals launder money through these companies to buy buildings and other assets, and law enforcement can't find who owns them. And as someone who sets up thousands of companies, I don't want the bad guys contacting us to set up their companies. I pound this into our staff on a regular basis that we only want good, clean, honest business and to turn all others away. Okay, now that background, let's get to the bottom line. As a business owner or practitioner, what do you have to do? Now, when setting up a company, you must report the beneficial owners to FinCEN. Now, so I don't keep repeating myself, here's how the Act defines beneficial owner. A beneficial owner is someone who exercises substantial control over a corporation or LLC formed in a U.S. state or Indian territory, like through a contract. Number two, someone who owns 25% or more of the company. Or number three, someone who receives substantial economic benefits from its assets. So one or more of those things, control, ownership, benefits, as stated above, are what the Corporation Transparency Act calls a beneficial owner. Now, when you form a company or are a beneficial owner, you must provide FinCEN these four things. For U.S. people, you must report their full legal name, their date of birth, a current residential or business street address, a passport or driver's license or other government-issued ID number. Now, it doesn't say you need a copy of that document. It just says that you need to report the number from that document. No financial information or details about the business purpose or its operation is required. Just those four things: name, birth date, address, and ID number. Now, if you are an applicant, such as an attorney, setting up a company and are not a beneficial owner of the entity, you not only need to report all beneficial owners, you also need to provide the same information on yourself as the applicant. Now, for foreign people, it's different. For foreign beneficial owners who don't have U.S. driver's licenses or passports, the applicant must provide these five things: full legal name, their current residential or business street address, a unique identifying number from a non-expired passport issued by a foreign government, and a legible and credible copy of the pages of a non-expired passport issued by the government of a foreign country bearing the photograph, date of birth, and unique identifying information for each beneficial owner. Plus, number five, written certification that the applicant has obtained the following for each beneficial owner: a current address, a legible and credible copy of the proper pages of their passport, verified the legal name, address, and identifying documents of each person, and they will provide that information to FinCEN upon request, the proof that they verified it, and they will keep a copy of the ID and proof that they verified the information, and keep all of that for 5 years after the corporation or LLC terminates. So not just 5 years after you file it, 5 years after the company is defunct, which can be 10, 20, 50, or 100 years or more, and 5 years after that. So apparently they need you to put all these paper into your coffin so they can dig you up and find out who owns it. So there you go. But don't worry, give us a call, and we have attorneys on staff, and we have a service where we can help you comply with this law. We also sell extra large coffins for those who file lots of companies. Now, what about existing companies? You have to report this within 2 years after the final regulations are issued to carry out this section. Now, the law was enacted on January 1st, 2021. Yes, lawmakers actually worked on a holiday. So according to this, if the regulations to enforce this were already in place, you have until December 31st, 2022 to provide FinCEN with the above items for existing companies. Now, I called FinCEN, spoke to several people, and they didn't have a clue what I was talking about. So they need to get their act together now. However, for new companies formed after January 21st, 2021, I saw nothing in the provisions saying that you did not have to file it right now. So in my opinion, based on this reading, the law is file immediately. Now let's talk privacy. Someone can only get your beneficial owner information that's been reported to FinCEN in these three ways: a request by a local, tribal, state, or federal law enforcement agency. Number two, a request made by a federal agency on behalf of a law enforcement agency of another country, and each must prove to FinCEN that they really have the right to it. And number three, a request made by a financial institution with consumer consent. So unless you're a bad guy, you really have nothing to worry about. Not even a bank can get the information without your consent. Okay, now, you need to file this information every year, just like you file your taxes every year. This is an annual filing. and more about privacy later. Bearer shares. The law also outlaws bearer shares. Those are stock certificates made out to the bearer. Whoever holds the stock certificate owns it. And that's something we used to offer to clients back in the early 90s when I first started in this business. Those are outlawed. Penalties. Now, bad things can happen if you provide false ownership information or fake ID documents to FinCEN, and this is a big one. You willfully failed to provide complete or updated beneficial ownership information. Or number 3, you receive a subpoena and you knowingly disclose its existence or other request for beneficial ownership information, unless doing so is needed to fulfill the request or the law enforcement agency authorizes it. So if you do any of those 3 things, provide fake info, willfully fail to provide the info, or blabber about a subpoena for the info, you can be subject to a civil penalty for up to $10,000 and under Title 18, which is $250,000 for individuals and $500,000 for organizations, plus up to 3 years in prison. And it also adds that if you're negligent, say you didn't know you had to do these things, you are not going to get into trouble, and the Secretary of the Treasury can waive the penalty if it was due to reasonable cause and not willful neglect. Now let's talk more about privacy. Now here are some of the amazingly good things. Now when I read this provision, I really almost hit the floor. This, I think, is a good thing for privacy advocates. Now, I don't know of any other laws like this in America. Even the privacy laws in Switzerland and other tax privacy havens don't have this. Okay, let me read you some of the law here. It says criminal penalty for the misuse or unauthorized disclosure of beneficial ownership information. It says the criminal penalties provided under 5322 shall apply. That is, Title 31 of U.S. Code Section 5322 says you can be fined for not more than $250,000 or imprisoned for not more than 5 years or both. So if I read that right, which I think I did, disclosing the owner of a U.S. corporation or LLC, and you may have to shell out over $250,000 and sit in the clink for 5 years. So they gather this information from owners, but only agencies such as law enforcement doing investigations can access it. That means that even someone sniffing around who's trying to sue you or actually does sue you in civil court cannot access it. Better yet for privacy, it clearly states that you can have a nominee, such as a nominee officer or director in the public records, so your name doesn't show up for someone who might be sniffing around for assets. Now, this is a service that we provide for law-abiding citizens who want to protect their assets from prying eyes. So FinCEN will know who the owners are, but that big ugly guy who wants to sue you may not. Beneficial owners don't include minor children, nominees, and the like, a mere employee, or one who inherited the company, or a creditor of a company unless the creditor is also a beneficial owner. Offshore companies. Again, the law does not apply to offshore corporations or LLCs. We set up tens of thousands of offshore companies for law-abiding citizens, and you can visit us at offshorecompany.com. So you can have an offshore company and this law does not apply. Exempt companies. The full reporting requirement also does not apply to publicly traded companies, financial institutions such as banks, or exempt nonprofits such as churches. Now here's a big one. If you have more than 20 full-time employees in the U.S., your income taxes show more than $5 million in gross receipts, and you have an operating presence in an office in the U.S., you are exempt. Or if the Secretary of Treasury and the U.S. Attorney both agree that you should be exempt. But as we said, even if you are exempt from reporting, you still have to file a report as to which particular provision in the code makes you exempt, and the person filing the report must provide the same information that a beneficial owner would have to provide, such as name, address, birth date, and ID numbers. So all U.S. companies, even companies that are exempt from reporting, still have to file a report. So what are the takeaways from all this? First, every U.S. company needs to file a report to FinCEN, even exempt companies. If you set up a company for others, such as an attorney, you need to report the beneficial owners as well as yourself. This law applies to U.S. companies only, not offshore ones, and not to trusts like the ones we set up. So if you need help fulfilling this requirement, don't sweat it. We have a service where you can hire us to do this for you. Our number is 1-661-310-2931, or you can visit us at assetprotectionplanners.com. And please be sure to click the like button and subscribe to this channel. This is The Business Guy.